Hey everybody, it's Clay Cheshire again with Munitions Law Group. Again, we're going to continue this series of I think issues that are pertinent to licensees, FFLs, and hopefully some of this stuff is useful. This is what we do all day, every day. It's easy to talk about, probably too easy to talk about. I know my daughters love YouTube Kids. We have to watch what they're watching. And I told them I was going to be doing some YouTube videos, and I think they think it's going to be something a lot more interesting, and it's not. So when I show this to them, I don't think they're going to like them very much. But hopefully there's some good information in here for those of you who are licensees now. And that's really what we're going to talk about today. It's pertinent to, it's not pertinent necessarily to people who want to get into the industry, but it's pertinent for people who are in the industry now and who are potentially, I think, looking to grow or potentially exit, sell, merge, consolidate, whatever you want to call it. And we're just going to call this deal issues. We do a lot of work on deals. It's not unusual for us to get to have someone at a big 3,000 lawyer firm call us and say, "Hey, we're working on this big deal. We don't have anybody at our firm that knows anything about firearms and ATF, and can you guys help?" And so we'll help them with some of the ATF compliance-related issues and State Department compliance-related issues and excise tax compliance-related issues that are pertinent to their deal. We also, a lot of times, are brought in by private equity funds or other what I'll call investor clients. And we sort of end up doing the same work over and over for the same client because they're in this phase where they're acquiring licensees, where they're doing some sort of a transaction, right? And generally, what you're talking about doing here is either, acquiring an existing licensee or its assets, or you're talking about, bringing in new investors or partners, or selling the business. And that's really sort of the universe of what we're talking about. And transactionally, you're talking about stock purchases, which is where the buyer is buying the equity, whether it's stock or membership interests in a licensee. Or you're talking about an asset purchase where your buyer is buying the inventory and the machinery and the goodwill and branding, the assets that belong to a licensee, but not buying the equity, okay? And you have mergers, and you have joint ventures, and you have conversions and redomestications and all kinds of transactional things that can happen. And what we always tell people when we have sort of an initial conversation with them is that the type of deal is going to dictate the ATF compliance setting. With an asset purchase, let's talk about that first. In that scenario, what's happening is you're having a new buyer, right? A buyer, which is typically an entity, so call it an LLC or a corporation, is coming in and saying, "I want to buy the equipment and the inventory and the branding from an existing licensee." In that scenario, the buyer it's the buyer's entity that is acquiring those assets. If it is going to conduct an ATF regulated business like manufacturing, then that buyer entity has to get a federal firearms license. It cannot operate under the selling entity's license because that license is not transferable. ATF issues licenses, they're issued personally to the licensee, right? So if you're an individual that holds an FFL as a sole proprietor, that license is issued to you and it's attached to your Social Security number. If you're an entity like a corporation or an LLC and you have an FFL for manufacturing, that FFL is attached to your EIN, your employer identification number, which is like the Social Security number for the entity. And it's personal to that company. So with an asset purchase, the buyer has to get a new FFL. With a stock purchase, it's different. The applicant, the licensee in a stock purchase is not changing. So let's say, for example, I own ABC LLC and I have a Type 7 manufacturing FFL. And I want to retire and do something else. So I get approached by somebody who wants to buy the stock or the membership interest of my LLC, the equity. Whether it's all of the equity, 30% of the equity, 80% of the equity, whatever, they come in, they want to buy, let's just assume 100% for this scenario. They want to buy the equity in my business. In that scenario, the entity that's the licensee, ABC LLC, is not changing. The owner of that entity is changing. The FFL is not transferring because it's going to continue to be held by ABC LLC, and those operations are going to continue to be conducted by ABC LLC. In that scenario, generally speaking, there's not a new license. I'll talk about that more in a minute. Generally speaking, there's not a new FFL that's required. But you do have to, there's a regulation that says that when there's a change of ownership or control of a licensee, that the licensee has to notify ATF of that change. And so, there's some detail that goes into this, but generally speaking, with a stock purchase, you don't have to get a new FFL, but you have to notify ATF of a change of ownership. Now, there can be scenarios where you do have to get a new FFL. For example, if FFLs last 3 years, and if your stock purchase is going to close 6 months before expiration of that FFL, then in that scenario, because what the reg will say is you have to notify ATF of a change of ownership or control, but when that license expires, you have to obtain it. You have to apply for a new one, submit a new Form 7, which is an application. So if you're dealing with a potential stock purchase or an equity purchase, and your FFL is going to expire in the next 6 months to 9 months, in that scenario, you need to sit down and do some planning about preparing and submitting a new FFL application, sort of the timing of doing that. And I guess the other thing that will come up too sometimes is where instead of you have 100% change of ownership or control, it's partial. Maybe you bring in a new 50% owner, and maybe you replace some of the officers. What we've done cautiously in the past in those scenarios is go ahead and do the notice to ATF, just to be proactive, because arguably there's a change of control, and so you go ahead and do that. Again, you'll hear me say this over and over again if you watch any of the videos that I do, but we're big believers in advanced planning. I mean, a little bit of advanced planning, it might cost you a little bit of money, but if you don't do that advanced planning and something gets done incorrectly, or God forbid you end up in a situation where you've got major compliance risk that could have been avoided with some planning, it's going to cost exponentially more, and you're going to have tremendous stress. So that advanced planning, avoids both of those issues. It manages your costs way better, and it certainly reduces the risk that you're going to have, stress, or more stress than normal. So we tell people, if you're looking at a potential transaction, identify the type of deal so that you can identify the regulatory requirements. Sometimes it's not really clear, like the scenarios I described. For example, if you've got a company in Texas that's domesticating into Georgia, and maybe converting from, a limited liability company into a corporation or vice versa, you've got to look at that scenario and figure out, under the law of Texas and Georgia, what's really happening to that entity. Is the EIN staying the same? Generally, if the EIN is staying the same, then it's going to be a stock purchase situation and not an asset purchase situation. So you got to look at the deal. Are new officers and directors, are changes to officers and directors enough to trigger the change of control, notice of change of control requirement. Are you going to add new RPs? Obviously, if you've got 100% change of ownership and the prior owner is an RP and isn't going to be an RP in the future, you're going to have to put at least one new RP in place. We always, again, recommend 2. But you need to add new RPs. And then, what we do with all this stuff, anytime we work on a deal, we use a tool that we call a tracker, and it's basically a checklist that we create. It's customized to each deal, but we use it as kind of a to-do list for every deal we're working on to make sure we don't miss something really important. And a lot of times the really important stuff is really simple, but the problem is if you don't create some tool to make sure that you identify all the things you're going to have to do and sort of the timing of each one of those things, then you can miss something, and missing something can cause downstream ancillary collateral damage that can be become a big problem. So that planning and creating these tools, these written documents and these trackers and things to help you be organized and make sure you don't miss anything. Those are designed. There's a little bit of investment in that, but the payoff is you're going to have a smoother transaction. You're minimizing the chance of any disruptions or surprises, and that's worth its weight in gold. So, is there anything we can ever do to help anybody who's thinking about a deal? Obviously, we're happy to help. That's it for today's video. I hope it was helpful. Everybody have a great day. Bye.